If you are in fear of death or great bodily harm, you have every right to defend yourself with whatever force you deem necessary to protect yourself, not what the police think or some district attorney or some, bleeding heart liberal or anything like that.
Come to me, come to me, come to me. Where's the guy? Come on, step out, step out, step out.
All right, don't say hello. Don't let me do it.
Both of you, step out.
Sam, thank you very much for coming on the show again. I've missed you, brother. I love the hat. Love the hoodie. You got your little sign on your hoodie there. I saw it. Nobody else can see it, but I did, and so I'm special. We got a lot to talk about with California. I mean, California is trying to make self-defense illegal. With that in mind, I wanted to find out where we were now. I know what I teach in the concealed carry course, and then I got thinking about it, and I thought, I wonder if what I'm teaching is actually accurate. So I did a little digging. So here's the status with the Castle Doctrine, which I know we have a pretty strong Castle Doctrine in California, in case you're unaware of that. I know Sam's aware of it. But here's the Castle Doctrine, which is 198.5 PC in our penal code, and this is what it says. Any person using force intended or likely to cause death or great bodily injury within his or her residence shall be presumed to have held a reasonable fear of imminent peril of death or great bodily injury to self, family, or a member of the household when that force is used against any person not a member of the family or household who unlawfully and forcibly enters or has unlawfully or forcibly entered the residence, and the person using the force knew or had reason to believe that an unlawful and forcible entry occurred. As used in this section, great bodily injury means a significant or substantial physical injury. So that particular statute is designed, the idea is that your home is your castle, and if somebody is doing some sort of hot burglary or home invasion, then the law will start out with a presumption that you faced a reasonable fear of death or serious bodily harm when you use deadly force to repel that invasion. And in California, it will protect you against prosecution, but not lawsuits, is my understanding. So that's the Castle Doctrine as it stands. Outside your home, we don't have a stand-your-ground law like Florida does. We don't have a stand-your-ground protection law. California is sort of a stand-your-ground state, sort of under common law and by court decision, but we don't have an affirmative protection law. But essentially, outside the home, I did my homework here ahead of time. Outside the home, California does not have a statutory stand-your-ground law that explicitly removes the duty to retreat in all public encounters. Under common law principles, self-defense is still permissible in California, but it must meet certain criteria. The person must reasonably believe they're facing an imminent threat. The force used must be proportionate to the threat. If retreat is safe and reasonable, courts have historically expected individuals to at least attempt to try to get away, but there's no legal requirement for that. And I pulled up one case. There are many cases, but California courts have repeatedly clarified that there is no absolute duty to retreat in every situation. For example, in People v. Hughes, 1955 and other cases, the courts have upheld that a person may stand their ground and use reasonable force if they are not the aggressor and are in a place where they have a legal right to be. Excuse me. However, this is not as broad, as I mentioned, or as explicit as a statutory stand-your-ground protection like they have in Florida, and juries obviously may still consider whether you tried to retreat or not. Now, that's the status as it is right now. But California, which is a state where we have legislators who would like to make every crime legal so that criminals never pay a price for anything, my understanding, Sam, is trying to make all of that go away and make self-defense illegal in some capacity or other, I think. So what's going on with that?
So you gave a perfect history of the Castle Doctrine, and as a matter of fact, it happened in California before the term castle doctrine was coined, and it was sponsored by our founder and chairman, Senator H.L. Richardson. He is the author of the first castle doctrine law in the country, and we did it right here in California. The presumption was always that you should not be held liable if somebody forcibly enters your home. Immediately, the presumption is that they are there to do great bodily harm or kill you. And so you have the right to use deadly force to defend yourself, and the law is on your side, not the criminal's side. What Here in California, we have this author, Assemblyman Rick Zver, and he sponsored AB-1333. And the guy doesn't know his rear end from a hot rock with regards to the penal code. He came up with this law that basically overturned self-defense in the home and outside the home. He had no idea what he was doing. And as a matter of fact, the criticism that he has received from both the Democrats and the Republicans has been scorching. And he said, "Oh, no, we're gonna amend this thing. This is not what we wanted to do. We wanted to prevent vigilantes like."
You're talking about Kyle Rittenhouse?
Yes.
Well, the man's an idiot. Kyle Rittenhouse was not a vigilante, but okay.
But a vigilante. He's not a vigilante. The court and the juries acquitted him of any crime.
Right.
They said he used appropriate self-defense. So you're trying to pass a bill to curtail the appropriate use of self-defense under the law, whether it's back east or here in California. That's crazy. But that's exactly what they want to do. They don't believe that harm should come to criminals, even when they are committing criminal acts, heinous acts, murderous acts. We shouldn't be able to defend ourselves and hurt them.
It's a little insane that these people who, in many cases, I don't know about this particular lawmaker, but in many cases, these folks don't have to suffer under the laws that they enact. Some of them, not all of them, but some of them are very, very wealthy, and some of them live in, protected communities and have personal security and all this other stuff. And, when they're at work, they're surrounded by the state police, up there at the Capitol. Nobody's going to harm them. If they get lots of threats, they can ask for protection. They're likely to get it. If you ask for threats, or you get threats, or I get threats, which very fortunately I don't, at least not lately anyway. Nobody hates me that I'm aware of. And if you do, don't threaten me. No, I'm kidding. But I don't get them. But if I got them, I'd call and ask for help, and the police department's not going to show up and protect me. But these folks don't have to live under this craziness that they want to pass all the time. What's the likelihood of this thing actually succeeding, do you think?
Well, there is a big kerfuffle, as my wife loves to use that term, going on in the state capitol right now. Not only because it turns self-defense on its head, but adding the requirement to retreat is really making people think, this is jacked up, this is messed up, and even in the legislature. So I fully expect that Assemblyman Zber will amend this bill. But frankly, our comment to him is, this is not a bill that can be amended in any way to make it acceptable.
No, kill it.
All.
Kill it.
That's
right.
all. That's right.
Right. So let's go back. Let's go back just 1 second, if you don't mind. What exactly does the bill do? Because I understand that it requires a duty to retreat, I think, and I don't know whether that applies to just public places or your home. And I understand that I'm not sure exactly what the bill does. Can you give us a kind of a bullet point breakdown on what this guy's trying to do with this thing?
This bill would eliminate certain circumstances under which homicide is justifiable, including, among others, in defense of a habitation or property. This bill would additionally clarify circumstances in which homicide is not justifiable, including, among others, when a person uses more force than is necessary to defend against a danger.
Okay, so let's pause right there because I think homicide is a word that gets used in the movies and TV a lot. So let's make sure we understand what homicide is. Homicide is just a legal term for the killing of a human being by another human being. So when one human being kills another human being, that's a homicide. Some homicide in our culture and laws is justifiable. Some homicide is not. When murder is an example of a homicide that is not justifiable. Manslaughter is an example of a homicide which is not justifiable. Self-defense, in the act of self-defense, when facing a deadly threat, in other words, you kill another human being to keep him from killing you, and that was an illegal, unjustified use of force. They're coming after you trying to kill you for no reason, or they're invading your home, or they're robbing you, or whatever, and you end up killing that individual to defend yourself. Under our laws and under our culture, that is considered justifiable homicide. So homicide is not necessarily murder or manslaughter or a crime, and people tend to conflate those two. So when Sam is reading that statute talking about what makes homicide justifiable and what does not, when I read you the earlier statute, the Castle Doctrine, it explained that when somebody currently in California law, if somebody's forcing into your home, they're committing some sort of a home invasion, and you kill that person or use deadly force against that person dies, then there's a presumption in the law that homicide was justifiable unless proven otherwise. Presumptions can be overcome. So if you shoot the guy in the back 6 times as he goes out the back door and he's trying to get away, that presumption is not going to help you, for example. So there's a presumption there saying within your home, under the Castle Doctrine, if you commit a homicide against somebody who is trying to forcibly enter, that's probably justifiable unless proven otherwise. And in public, if somebody's trying to rob you, kill you, or whatever, you have a right to stand and defend yourself wherever you have a legal right to be, currently in California. And if you end up killing that other person, there's a strong likelihood that homicide might be justifiable as long as what you did was reasonable and appropriate, which are unfortunately very subjective terms, and the jury, a jury full of unreasonable people, gets to determine what's reasonable or not, unfortunately. But that's kind of the way it stands right now. So now, with that understanding, would you read that change again for me, Sam? I want to make sure that I get it and they get it.
I'm going to read to you the actual language in the bill. That was the legislative digest, the summary.
Okay.
But this is the language. Homicide is not justifiable when committed by a person in all of the following cases. When the person was outside of their home and knew that using force likely to cause death or great bodily harm could have been avoided with complete safety by retreating. So there's your requirement to retreat in the statute. Number 2,
let's pause right there. First of all, there's no way to know that with absolute certainty if you're the person being attacked. And secondly, the people who are going to judge whether you should have known that are going to do it in the cold light of reflection, not in the middle of being attacked and almost killed. So anyway, go. What's the next one? As we happily tear this thing apart.
Yeah, this is super important. What you just said. Present law, when we teach CCW students and people who want to know about justifiable use of firearms, deadly force, we teach that you have to be in fear of your life or great bodily harm, and the amount of force that you use to defend yourself sometimes is scalable. A guy comes at you with a pencil, unless he's John Wick, you don't come back with a baseball bat. If a guy comes back with a crowbar or a monkey wrench, that can kill you. So then you are justified in using appropriate a gun, whatever you need to do to defend yourself and protect your life. This thing is turning that on its head. It is requiring people, it is going to kill people, that provision alone, by requiring people to stop and think in the instant, the nanosecond that they have to make a decision whether I need to use deadly force to protect myself right now, or I'm going to die, or I'm going to be maimed. The law in California wants you to think, oh, why don't you look over your shoulder? Are there places for you to be able to escape to? Can you retreat? Is and then you're going to have to prove to a jury that you did not think about escaping or retreating before you shot this criminal that was about ready to kill you. So this is egregious, Joel. This is not. Oops, I'm sorry. This is not what we meant. This is really bad stuff. So number two, when the person used more force than was necessary to defend against a danger, that's already present law. You cannot you cannot escalate a confrontation. A guy picks up a chair, you can't pull out a gun. Or there are
Guy's
rules and
poking his
laws.
finger in your chest. You don't get to shoot him.
That's correct.
Right.
That's correct. So thank you, Adam. That's the next. Then number three, when the person was the assailant engaged in mutual combat or knowingly engaged in conduct reasonably likely to provoke a person to commit a felony or do some great bodily injury, except if either of the following circumstances apply. A, the person reasonably believed that they were in imminent danger of death or great bodily harm and had exhausted every reasonable means to escape such danger other than use of deadly force likely to cause death or great bodily harm. And B, in good faith, the person withdrew from the encounter with the other assailant or assailants and indicated clearly to the other assailant or assailants that the person desired to withdraw and terminate the use of any force, but the other assailant or assailants continued or resumed the use of force.
Here's the problem with all this, and then I'll let you go through the rest of it. I don't think people understand that people believe that in our system of jurisprudence, you're innocent until proven guilty. And that's true, technically, but in a self-defense case, you're not. Because in a self-defense case, you've already confessed to the crime. You shot the dude full of holes and he died. And you've said, I did it. Or your attorney has said, he did it. What you're saying, though, so killing somebody can be a crime, and you've just said you did it. They don't have to prove that you did it. You did it. You said you did it. But what you said was, I did it, and I did it for the right reasons, which means the burden of proof shifts from the state proving that you did it, because you already said you did, to you proving that you did it for the right reasons. So now it's not an issue of being innocent until proven guilty. You've already proven you're guilty. Now you have to prove that the act of self-defense was done in accordance with law. The more they squeeze down how you can do that and how often you can do that and put all these rules together, the harder it is for the citizen to prove that what they did was appropriate, even in the most heinous attack, and the more likely the citizen is to end up in prison for doing exactly what they should have done at the time. That's what it boils down to me. But in any case, are there any more, or that's enough?
Well, those are the main provisions, but you're absolutely correct about mutual combat, except that there's a or added to that.
I missed that part. What was the or?
Well, let's see. It is when the person was the assailant engaged in mutual combat. Or
I missed that part.
Knowingly engage in conduct reasonably likely to provoke a person to commit a felony or do some great bodily injury, except if either of the following circumstances apply. So, this is the one where they were trying to get at Rittenhouse. The fact that he was there to defend and protect people in a violent protest. They would assume under this law that act provoked the felonies that were committed against him. So this, like I said,
one of the things that bothers me about the way that these lawmakers write laws is the words like reasonable, the reasonableness of it, the appropriateness of it, reasonably, appropriately. Those are very subjective terms, and nobody, as far as I know, has defined what reasonableness means. under the law. And so when you say if they are if they're doing something that could be reasonably construed to cause a violent situation, well, if you put 10 people in a room and ask them all what's reasonable, you're going to get 10 different
Correct.
answers. So this really is a quagmire, and it's a trap. Honestly, these things are set up to trap citizens who defend themselves. I don't care what the legislator is saying. If he honestly, earnestly is trying to prevent a Rittenhouse situation, this bill, he's an idiot. Okay, the dude's an imbecile. Okay, because of what he's written, and if he doesn't like it, I don't care. He's an idiot. This is crazy stuff. Anyway, I ask you what your thoughts are as far as whether it's going to be passed or not. What do you think?
I think some version of this thing is probably going to move forward. He's taking broadsides from all sides right now, and he has no defense. It's sponsored by Everytown for Gun Safety, of course. Zabur isn't smart enough to be able to conjure something like this up on his own. It has to be sponsored by, those publicly funded anti-gun organizations to the tune of $8.4 million a year through USAID. But that's what we have to fight. But they're the ones who sponsor the bill. And right now, Zbur, I'm sure, is having heated conversations with them about what the heck have you gotten me into here. And with regards to reasonableness, what it boils down is this. What can you convince a jury to decide? That's it. That's what's reasonable.
Right. And here's the other problem. I guess they're just slow. I hate to be insulting, but I think they're just slow mentally. Because as I'm looking at what's happening in California, California is moving kind of back to the middle again. I mean, we've been on this hard left road for a while, but nationally we've moved back to the middle, which is evidenced by the most recent presidential election and the mandate that President Trump has been given by virtue of that. But we're also seeing it happening in California. I think partly because of the demographic shift, you have a lot of very, very wealthy people who have traditionally sat around in their, giant homes protected by security and made themselves feel good by passing such idiotic laws that they don't have to deal with. But now you have the Palisades burnt down. Every one of those houses was worth millions. You got all those movie stars and people living in Pacific Palisades. You got all these, Malibu burned down. You have a bunch of, for lack of a better word, pissed off liberals. Plus, a lot of them have packed up and moved out of the state because it costs them a fortune to live here. And what's left is a lot of the middle class folks who never liked this stuff in the first place. And so it seems to me, as I look at it, that the voter base is changing. And the desires of the voter base, particularly the middle class, is more likely to be heard at the ballot box than it was before because you don't have this overwhelming liberal nonsense pushed by all these wealthy people. Don't these politicians recognize that this is changing and that this kind of crap is not going to be tolerated by Californians much longer? I mean, these people are going to be thrown out of office at some point, I hope. I don't know. Am I reading the state wrong? Sam, you got your finger on the pulse.
No, I think your evaluation and your overview of the situation is accurate, but you have to understand the nature of the players that are here. We have holdover, radical, progressive, left-wing, pinko, commie, whatever you want to call them, people that are in the majority or in the leadership, and they mandate what the rest of the Democrat Party does. And if they don't, they're not there anymore. The leadership doesn't realize that the chains of power are starting to break. That there are changes. We picked up a couple of seats in the assembly that we should not have picked up. There's a demographic change that we picked up another seat in the Senate we should not have picked up, but we did. And it's going to continue to move in that direction. The curse of the fires that happened in Southern California have are turning out to be a little bit of a blessing because it's really pulling the curtain back from the Democrat leadership and what they are and what they believe in, and all of the problems that they've created for California. Now we find out that Gavin Newsom, up to 6 years ago, had a plan for how to protect Southern California in the case of wildfires and disaster, and he ignored it.
Yeah.
The water plan and the mayor of Los Angeles, she's floundering right now. She's a babbling bonehead. They're going to recall her. The Los Angeles may lose the Olympics in a few years because of all of this disaster, and it's going to take a while to clean out the holdouts in the legislature in California, and they are the leadership. They're the ones who are running the show. Senator Richardson always said, not all Democrats are the radical leftist. It is a hardcore group within the Democrat Party that makes up a majority of that caucus that are the loud rabble rousers. And they are still in charge, and they're holding on with their fingernails to power, and they don't see it slipping away. The Hispanic community is moving to the right. The Asian community is moving to the right in big droves, and it isn't anything other than they're coming to the realization that I need to be my own first line of defense. The economy in California is crazy. Why are they preventing my kids from going and entering schools because they're Asian and they're smart? Why are they why are they keeping the Hispanic community down? Because when they keep them down, they keep them beholden to the leadership. They give them little treats here and there in order to satisfy them, to make them think that we are your friends, when in fact your best friend is freedom and liberty to do whatever the heck you want to do without the oppression of government. So we're in that situation, and I think it's going to take maybe a couple more cycles. Hopefully before the end of the Trump administration to make some significant changes here. The first big change will be that we take away their two-thirds supermajority in either or both houses. That right there will break their ankles.
The what would traditionally be thought of as people who would be naturally on the hard left, they're not, and they're moving over to what can only be called good sense or common. I don't know if you call it common sense because it's not all too common, but we're moving back to, what's good for people, regardless of their lifestyle or what their ethnic heritage is or what language they speak or how they make their rice. It doesn't matter. Everybody's life is important to them, and they all want to protect it. So when some idiot up in Sacramento is trying to take away the right to protect yourself and your family, I mean, think about that. If you're my son and his wife, and you've got two children, and you're home, and somebody's breaking into your house, you're not just protecting yourself; you're protecting your kids, you're protecting your whole family. And now California says you got to gather up your whole family and see if you can get out the back door, because if you don't try to retreat first, this is your own home, and people are barging into your home. So this is a law that is just really so far left that it's absurd. You said you think it'll move forward. Where is it now, and how far do you think it will get? And I got two questions. And the third one is, do we have a chance, do you think, of killing it entirely before it becomes law?
I think there are plenty of opportunities to either kill it or amend this into oblivion so that it becomes a bill about painting yellow stripes on the roads. Just totally off subject. I think that Assemblyman Burr his feathers have been not trimmed, but plucked out at the root, and his bill is so bad that his staff hasn't even been able to come up with a fact sheet. Typically when an author writes a bill, they develop a fact sheet that talks about the sponsors, the purpose of the bill, what the bill does, and for more information, contact our office, Assemblyman Burr, State Capitol, and he gives his phone number and email address and stuff like that. The staff, for over 2 weeks, has not been able to come up with any sort of a fact sheet on what this bill actually does, because they don't know. They have had it explained to them that this thing is a really bad thing and it's going to kill people Innocent people are the ones who are going to be the victims of this law, not vigilantes or anything. It is the law-abiding citizens who have the right to defend themselves, except in the state of California, who are going to die.
And so California, in making an effort to make it illegal to defend yourself, on top of trying to make the entire state a sensitive place where even if you have a concealed carry permit, which you have to go through the rectal exam to get in this state, and then you can't carry it anywhere because they try to make it illegal for you to do so, is just an effort of California politicians to make the concealed carry permit useless and to make it impossible for you as an honest, hardworking American who happens to live in this commie state to defend yourself and your family.
You are absolutely correct. There is nothing that you said that is off base. Here in California, we are obviously having to fight for our fundamental, basic, God-given rights of self-defense, because the other side is working actively, not just talking about taking our rights away, actively working to make our rights illegal. Under any and all circumstances, under American laws, except here in California, if you are in fear of death or great bodily harm, you have every right to defend yourself with whatever force you deem necessary to protect yourself, not what the police think or some district attorney or some, bleeding heart liberal or anything like that, what you believe. And then you tell your story to the jury. Joel, I've been blessed. I've been blessed 3 times with having to draw my concealed firearm. One was in a home invasion, one was in a bank robbery, and one was a situation of road rage. I've talked about it before on the show. Blessed that I did not have to pull the trigger, but unbelievably grateful that I had that firearm to be able to protect myself and the people around me.
Sam, we've run ourselves out of time. Can we come back another time and talk about the rest of what's going on in California?
Absolutely, but before we go on, when you said that the best antiseptic is light, through my mind is the best antiseptic is amputation. But
okay, we might have to do some of that too.
My mind was rolling. Absolutely, there's so much more to cover. We've got 20 different bills that we are considering this year right now. And some of them are good.
Some of them are not.
Really bad, and a couple of them are heinous, and there is plenty to talk about. And 1333 is one of the bad ones, but there are others that will.
Okay, so what we'll do, Sam, is we're out of time. Is we will come back and we'll go through all of those. How about that?
Love you, man.